I'm Stephen Maritos, the partner who heads up what we term the LTPS work here at Hempsons in terms of employers' liability, public liability claims. And I'll let Aisha introduce herself. She's one of the team members we've got. Aisha.
Good afternoon, everybody. Thank you for joining us today. My name is Aisha Zaria. I'm a solicitor within the healthcare team. I'm also part of Stephen's team working on these employer liability as well as the clinical negligence claims. I'd just like to thank Thomas for joining us and leading this webinar today. And I'm going to pass it over to him to commence the webinar.
Thanks very much, both of you, and thanks, Heather. Yes, I'm Thomas, although Tom is absolutely fine. I'm a barrister at Decker Chambers. My practice tends to focus at the intersection of public and private law. So I do a number of judicial review challenges, but I also deal with private law claims and negligence against public bodies. And I do a fair bit of work in the health and social care space, both clinical negligence and employers and vicarious liability type claims. So I am going to start off talking about disclosure and employers liability claims. The purpose of my talk is not really to teach grandmother how to suck eggs. It's not about health and safety in the workplace per se. I imagine most practitioners on this call already know far more about that than I do. It's about bringing a litigator's perspective to all of this. Not necessarily how can we keep everyone safe, no matter how noble an idea that is, but how can we defend ourselves against litigation in this space? And obviously, the best defense is always preventative. So, of course, there's going to be overlap here. The best way to defend litigation is to have the right structures in place in the first place. And I guess you can say that if the litigation industry has a social value, it's aiming for that hoped for outcome whereby via litigation we prevent further accidents happening in the future, and we all aim towards that utopian society where nobody gets hurt in the first place. So that's by way of introduction, and if we go to the next slide, it is first principles first. So typically in litigation of this type, defendants start on the back foot, and that's because there is the fact of an injury taking place in the workplace, and it's typically only witnessed by either the claimant or the claimant and others who are likely to support her in or him in the litigation. It's unlikely and uncommon in my experience that you have a first-hand witness account from a defendant in this space challenging the factual premises of the actual injury. And that means that you're effectively starting on the back foot. You can't in most cases challenge the fact of the accident. You normally have to defend the case by way of evidencing how good a system of health and safety you have. And typically the witnesses who are called to appear on behalf of defendants in these types of cases are not people who've witnessed the accident themselves, although that does happen, of course, but more typically those who are able to speak to the system of health and safety which operated at the time. And really then it's a case of oral evidence on the claimant side about their experience in the workplace versus on the defendant's side, a whole tranche of documents. And that's why this talk really is called Defense by 1,000 Documents. The documentation is the key to defending these types of cases. Now, in any employer's liability case, the first principle is, well, what is the duty of care? And the employer's duty of care really has two prongs to it. It is one, the duty to operate a safe system of work, and it is two, the duty to reduce to as low a level as is reasonably practicable the risks of injury in the workplace. And that second limb is often forgotten, and I'll come back to that in just a second, but it is a key part to the employer's duty, that reasonably practicable point. So I'll come back to that slightly later on. My experience in these types of cases is that all too frequently there is a problem with documentation. So there I am in front of a judge, or it's either me or it's in fact the witness who's being cross-examined in the witness box, and either the barrister for the other side or the judge is saying, well, where can I find that information that you're telling us? Have you got a document which shows that? And the witness or counsel is scrambling around saying, well, no, don't actually have that document, but I know that that document did once exist, but it was lost on the system somewhere or somehow. That happens a lot. Or you produce a document and the judge says, well, that doesn't really tell me much because it doesn't have much information on it. Another thing that happens a lot in these types of cases is that something turns up on the day of the trial or a few days before the trial, a piece of documentation which hitherto hadn't existed or hadn't ever been produced, and that causes all sorts of problems in these types of litigation. Questions about why documents can't be produced when they ought to be able to be produced. Issues of having the wrong witness to speak to some of these issues. You have a whole host of documentation and the witness says, well, sorry, these aren't actually my documents, so I don't really know much about them and I can't really speak too much about them. That happens a fair bit as well. And it's not a criticism of how these cases are prepared, because it is incredibly difficult to get this right. It is just some of the common pits and traps and pitfalls that you encounter in these types of litigation. And the best way to tackle that is to have your documentation all in order from as early as possible in the litigation, preferably before the claim is even issued, so you can get rid of it preventatively rather than retroactively. So the first prong of the duty was that safe system of work. What documents do we have that show the safe system of work? Well, the first document really that goes front and center in any of these types of things is the health and safety policy. The health and safety policy is the blueprint on which the rest of your health and safety system is built. So these are high-level strategic documents. The objective really in every health and safety policy is the same. It is our strategic aim is to keep our employees in the workplace safe. And I should say not just employees, but also visitors to the workplace. Yeah, our strategic aim is to keep everyone safe. Well, that's great and that's noble. How do we do that? Well, you can put into your health and safety policy things like your janitorial strategy, what you're going to do about sweeping, mopping, tidying up, etc. You can put things about your working at height strategy. Try and avoid it wherever possible. Put things in it definitely about training. How you're going to achieve your strategic aim? Well, you're going to make sure your staff are all trained in manual handling operations or wherever it might be. And you often see in these types of documents the very common phrase that you see, and I'm sure in lots of people on this talks, health and safety policies, they have the same thing, which is health and safety in the workplace is the responsibility of everyone. It is not a top-down, the employer has all the responsibility and the employee has none. This is the responsibility of everyone in the workplace. Well, that is great and that is important, and that is what this document should say. But if you say that, you have to demonstrate in your health and safety policy how you empower people in that regard. How do you empower people to look after their own health and safety in the workplace? So good examples of that, if this kind of document, are ones where it doesn't just say, this is our strategic aim, everyone needs to be safe, but also these are the lower level strategies for how we're going to achieve that. We want people to take some responsibility themselves, and we're going to do that by way of training, by way of other types of engagement activities, whatever it might be, workshops, whatever. But let's put those in those documents, so the document isn't just a bland, this is our strategic aim, but it actually gives us a little bit of lower level strategy for how we achieve that. And I say here they're relatively static documents. We're not changing our health and safety policy every week or month or even half yearly. We might edit it every year, say, but it's mostly static, and we update it based on learning that we achieve from, unfortunately, incidents potentially happening in the workplace or near misses. Beneath that, risk assessments. Now, risk assessments are probably the bane of litigators' lives. It is always an issue, in my experience, in these types of cases. Is there a risk assessment? Is the first question. Does the risk assessment actually deal with the type of accident which the claimant in any given case is experiencing? And is the risk assessment actually adequate? Does it really tell us anything about what is being done about the risk beyond simply the risk being identified? So it is really important in these documents that you have granular detail. Something like slips, trips, and falls as one row on a spreadsheet, and then a rather vague control mechanism of any slippages any spillages are cleaned up as quickly as possible, or whatever it might be. That's not really good enough. Slips, trips, and falls are three different types of things, and slips can happen because of spillages on the floor, most likely. Trips are more likely to happen because of obstacles on the floor that have more of a physical three-dimensional shape to them than a spillage does. Falls are different as well. They're potentially things like staircases, or coming off a chair or a table or a stool or whatever it might be. These are three different things, and they should be risk assessed in three different ways, and really show your working about how you're going to control them. And that's important because, as I say, in litigation, we put these documents in front of a judge and we say, look, this is great. We've done a risk assessment and it identifies the risk of slipping. And then the judge says, OK, well, what have you done about that? And you point to the controls column on the table and it says something bland like, clean up the spillages. Well, great, but let's have a bit more granular detail in that, which enables us to say, look, this is how we are actually controlling this risk. We're going to do inspections at X frequency or Y frequency, or if we can't put that level of detail in the risk assessment, we're at least going to show that elsewhere we're going to think about inspection frequency and so on, and show the difference between a controlled environment and an uncontrolled environment. So what does the risk look like if you don't have any controls versus what does the risk look like now that we have got it controlled? And when you get those risk assessments that have the numbers on them, the matrix multiplications of impact and probability, the ones that really kind of demonstrate the thinking are the ones where you can see a number go from high to low or medium to low or whatever it might be. The other important thing to show on these documents is that they're living documents. They're updated regularly, and so that can be updated with a regular frequency, once every 6 months, once every 12 months, whatever it is, but also that there are ad hoc updates whenever there are accidents or near misses in the workplace. Keep those updated and show on the face of the documents that they are updated whenever there are accidents and near misses. And then the other key thing in litigation is, well, this is great, Mr. Yarrow, you've done a fantastic risk assessment here. Can you show me when this was communicated to the claimant? And then you're stuck saying, well, it was posted on the intranet, or there was somewhere a notice board where it might have been, or a file somewhere where the claimant would have had an opportunity to read it. Well, that's not really good enough. You really want to communicate to individual claimants what their risks are in the workplace, so that when it comes to litigation, you can say, well, I'm sorry, the claimant was well aware of the problem here. We did a risk assessment, we identified the problem, and we told him or her that there was a risk for him in the workplace and that this is how he should have behaved in order to avoid it, and he didn't do it. And if you're able to show that, then that is almost a full answer to most claims. But in my experience, all too commonly, we don't get there because there's some kind of problem. Right, safe system of work documents. These really are the controls of a risk assessment in action. These are the set of procedures for any given task. So let's say there's a task in one day to move a load of equipment from one ward of a hospital to another ward of a hospital. And during it causes an injury to someone during the movement of transporting equipment. Something falls over or whatever it might be. Well, what do you turn to? You turn to, does the defendant have a safe system of work document covering the activity that we're talking about? So this is not just the risk assessment, which says, in general, in the hospital, there are risks of people kind of bumping into obstacles or falling over or whatever it might be. This is a specific risk that is associated with performing a specific task, i.e. we are moving all of our items of equipment from one ward to another. We recognise that in doing that, there are going to be risks to the health and safety of our employees, maybe manual handling, there are sprains and things, maybe obstacles might fall off things and onto people's feet or whatever it might be. So the safe system of work document tells you, well, this is how we're going to specifically design this task in order to avoid accidents happening. And now these are the opposite really to a health and safety policy, which is broad, not deep. These are deep, not broad. And it's important in these to look at what the various health and safety regulations say. Your manual handling, your work at height regulations, use of work equipment regulations, your personal protective equipment regulations, lifting operations and lifting equipment, display screens, whatever it might be. But look at those particular regulations and identify the particular risks that are associated with performing particular tasks. And these documents are often, again, if done really well, are a really good answer to something that goes wrong in the process, if, again, they are communicated to the claimant. No good having the document if you can't show how the claimant, in this case, understood it. Training. Okay, this one's really important. This is the evidence of communication. I've said a couple of times already today how important it is to communicate your health and safety policy to your claimant, or the way in which you do it is particularly through training. And I've got a picture of lemmings on the side here because the point I'm trying to emphasize is that training needs to cover the obvious as well as the less obvious. You kind of have to train someone who's working to not do silly things, not to, use a makeshift tower of files in order to stand on to reach something at the top of a shelf or whatever it might be. Train the claimant on the obvious, or the employee in this case, on the obvious. And the best documentation for these, the best things to put in front of a court, are not just the slides or the handouts from the particular training, but also the bit of the process where the claimant employee demonstrated that they had taken in the training and understood it. So in its most straightforward way, that's a signature at the bottom of the page. I, Joe Bloggs, confirmed that on the 15th of August 2021, I completed my manual handling operations training. Signature. That's good to a certain extent. What's better is e-learning records or document tests, as it were, which evidence that the claimant has actually given more attention to it than just, I was in a room when someone was talking to me. I was in a room when someone was talking to me, and I then had to engage with a short quiz at the end of it where I had to demonstrate that when I lift up heavy things, I bend from the legs and not from the back, or whatever it might be. So the best documents in these cases are the ones where you can evidence a two-way story. you've got the e-learning in particular is really good for this, because you can show that they completed it and what the questions were that they were asked and how they answered it. So that's documentation there. Keep your topics separate. One thing I see a lot in litigation is where essentially it says something like, on the 15th of August 2021, I completed my manual handling operations task, my use of PPE, my working at height, my use of work equipment, my use of display screens, whatever it might be. 3 hours worth of training, potentially, great, but all done on one day, all compressed within, a single slide pack or whatever it might be. And that presents a difficulty, because then the claimant comes in front of a judge and says, well, yes, I did do the training, I vaguely remember it, but there was just too much for me to take in, and I was never going to be able to apply all of that on a day-to-day basis. So keep your topics separate, try and do them at different times of the year, keep things refreshed as we go, and feed back into your training the lessons that you've learned along the way. Right, next type of documents we often get in litigation, conversation records. Well, the question is, well, you normally get a witness that says, well, I was the one who conducted the training, and or I had a conversation with the claimant where I said, please don't do that in this way. Well, that's fantastic evidence, but if you've got a document that evidences that, that's even better evidence. If it's a meeting before a task, if let's say everyone needs to move the ward again, that's an example of a type of case that we've handled previously. If we're moving a ward from ward A, equipment from a ward, we have a meeting before that move is done. We talk through the safe system of work document that we've already designed, and we minute that meeting. And then we can say to the judge, well, look, here it is. Here's the safe system of work document. This was the task. And also, here are the minutes of the meeting where it was clearly communicated to the claimant. So those are really useful documents in litigation. The next set of things is inspection records. These are super important in any slippage type of case, because in these types of cases, from a legal perspective, there is what's called a burden of proof shift, and suddenly the burden of proof moves away from the claimant, who no longer needs to prove that the defendant was negligent. The burden shifts to the defendant to show that, notwithstanding there was a spilt pot of yogurt on the floor a spilt pot of yogurt in the floor of the canteen, nevertheless, we had a really good system of inspection and maintenance going on, whereby every half an hour there would be a floor walk of someone with a mop, or there was constant surveillance. The staff in the canteen were trained to keep an eye open, and they would always just pop their heads out from behind the counters and look for spillages in order to address them. And really inspection records should have as granular detail as possible. Check all of your equipment. If it's an equipment type inspection checklist, check all of your areas of floor if it's an obstacles and slips type inspection record. And just because you're going through a checklist, probably that's the best way of doing it. I check this, yes, tick. I check this, yes, tick. It doesn't mean it's what's in common parlance known as a tick box exercise, which is something that you don't really pay much attention to. You just mark off all the boxes. Do it properly. And record both your findings and non-findings. That's really helpful from a litigation point of view, because if you find nothing, that's great, but please document it. Sometimes you get things which are, this document is silent on the fact of any issues with the staircase because we didn't find any issues with the staircase. Well, great, but document the fact that you didn't find any issues with the staircase. Accident reports, statics and RIDOR reports, these are often the best factual evidence of the accident, and they're useful sometimes because they can highlight discrepancies between what a claimant says at the time of the accident and what they later say about their accident. So really important records, these. people are often loath, I find, to put too much into a RIDOR report or an accident report, a DATIX record, wherever it might be, because of a kind of defensiveness to litigation. We don't want to put too much in here because we're worried that it might be used against us in the future. We don't want to address this hazard too vociferously, because if we did so, it might suggest that we weren't doing things properly before the accident. Well, actually, speaking as someone who defends these types of things quite a lot, judges are often really persuaded by the idea that a bad report is evidence of a poor system. A really good report, which addresses the accident in a lot of detail, is not a confession of wrongdoing, but rather evidence of a really good system in operation, which takes on board a kind of learning and feedback type exercise and says, look, something went wrong here. We think we did everything we could, but actually thinking about it, we can change things a little bit, and we're going to change things a little bit. And that's not a confession of wrongdoing. That's just a really good responsive system working in the way that it should. And the final bullet on this slide, I say involve injured party as much as possible in all processes. That's something that is often preventative to litigation in the first place. If the injured party really feels like their experience has been listened to and understood, they're less likely to sue you for negligence. A lot of the time, I find in litigation, claimants saying, it's not about the money for me. Now, that might be an element of not quite telling the truth. Often it is about money, but you hear it all the time. It's not about money for me. It's about making sure this never happens to someone else in my position. Well, great. If you can do that with the post-accident response, then you've prevented the litigation in the first place. Now, this was the bit that I heralded at the beginning, the lowest level reasonably practicable. This is often forgotten in litigation. This means that you don't have to create a perfect workspace. You just have to do what you can to get it to the lowest level that is reasonably practicable. So one of the answers, one of the key defenses is saying, well, of course we could have prevented this accident from happening if we had employed 5 more staff at the time, but that wasn't reasonably practicable. And that's a great defense. It's fantastic defense. You say, I'm sorry, obviously in an ideal world, we would have had more resources. We would have had more money. We would have had more time, but we didn't, and we don't. And the reason we don't is, and then you hand some documents or you give some evidence by way of witness statement. Our budget that year was X and we could only afford to do A, B, and C, and we just couldn't afford to do D. And we really thought about the problem. And unfortunately, we couldn't solve it. That's a great defense to this litigation, because you've said, look, we're trying to reduce it. We've reduced it to the lowest level, but to go beyond that level would not be reasonably practicable. And I've had cases where effectively a judge, regrettably, has effectively put themselves into the shoes of an NHS resourcing manager and said, well, I'm sorry, you should have had more nurses on duty that day. And that's because the defendant wasn't able to produce the evidence that said, obviously, we couldn't have more nurses on duty that day because that would have cost us more money than we had to spend. So don't forget to evidence the lowest level reasonably practicable. Not much to say hugely about this slide. It's just other documents that are relevant in litigation: photographs and plans, occupational health records, personnel files. Keep them safe because we might need them in litigation. Other issues, IT, this always goes wrong, and this happens in litigation a lot. You say, well, I'm sorry, unfortunately, I'm not able to access the risk assessment from the year before the claimant's accident because it was an old legacy system which I don't have access to anymore, or whatever it might be. Just be mindful of the problems that IT can create and try and get as many documents in order from an early point in the litigation, because if it's going to take you several months to retrieve the relevant document from Iron Mountain or wherever it might be, then you want to start that ball rolling at the start rather than 3 days before trial. Yes, this is a slide that I think it speaks for itself about what we do with witness statements. Speak to facts, no opinions. Explain the documents, don't just exhibit them. You see that a lot of witness statements. Here's an exhibit. Well, talk me through it. Tell me what it says. Show me the theory, show me the practice as well. Show me how the system is implemented in practice. Don't duplicate, don't take things personally, stay relevant and be brief where you can, but don't just be brief to avoid having to be cross-examined on things, because you'll end up having to be cross-examined anyway, and all that will happen is the judge will get cross. So make sure we've got the information we need in there in those witness statements. And that concludes the end of my talk. Sorry, I know I was talking quite fast and there was a fair bit to get through, and I perhaps run on a little bit longer than I intended, but thank you very much for listening to that.
Thank you, Tom. That was really helpful. I just want to reiterate what Tom was saying, in terms of the key documents that we're looking for in order to defend these cases. So the first thing is, as you'll be aware, the employer must show that all steps that have been taken are reasonable to minimise the risk of injury towards their staff members. So the first document, as Tom mentioned, is the DATICS report. Like he said, this is a key document, and it's often completed by the person that was injured, i.e. the person that was made the claim. So when we review the case itself, we look at what they reported at the onset, who did they speak to, what investigations were carried out, and what were the results of those investigations. Another key document that we look out for are the trust policies. Now, just to give you an example of the sort of cases that we have come across, for example, if a staff member was restraining a patient, that patient then attacks them, it causes injury to the staff member, we want to see within those trust policies that there is something in place to confirm the training that had been carried out or what the staff member should have done in that situation. In terms of the risk assessment documents, now, as a lot of you that have joined are aware, patient care is the centre of everything that NHS do. So the risk assessments identify the hazards, they decide who might be harmed and evaluate the risk. So we want to see if the trust have controls in place that minimise that risk or reduce that risk. For example, if a staff member is using an equipment where there is a risk of injury, we want to see that the hazard has been considered. In terms of the staff member comments, now again turning back to the DATICS or the HSC reports, we want to be able to test the factual evidence and their version of events. We want to speak to these people at the outset. We want to know what exactly what had happened, where things may have gone wrong. We want to know from their point of view how things potentially could have been prevented or how they can be improved. Now, at the outset, when we do get these documents, it's helpful for us. Then we were able to consider if we are at litigation risk, which means that there will be a risk of being unsuccessful if we continue to defend the case to trial. And ultimately, that means that we can consider whether it's necessary to make admissions on liability or even offers of settlement. In terms of the training records, again, we want to see what the staff member has been trained to carry out in their job role. Going back to the example of the sort of cases that we have dealt with, if a staff member's role includes lifting a patient, we want to see that the staff member is trained and appropriately can do this in a safe manner, which is through the manual handling training. And going back to what Tom mentioned, it's helpful to have some context when we are provided with these sorts of records. And it's the same with the return to work documents and the meeting from minutes. So how can you help us defend the claim? As I expressed, it's really important to speak to the staff members and get their comments. we're often picking up these claims a year, 2 years later. At that point, staff members can't remember what had happened. They can't remember conversations or the incident. So as soon as you are aware of an incident, it would be really helpful if you can just speak to the person that were involved, that were named on the DATEX or the HSE reports, and obtain their comments. We'd also be helpful to ensure that the training is up to date for all the staff members, ensure that policies are up to date. We sometimes get a claim where an incident took place in 2022. We're provided with policies from 2023, and it's not really going to be that helpful to us. It would be more useful if we have something that was more relevant or that was relevant at the time of the incident. The key thing is that we want to learn from these claims and we want to prevent injuries from occurring to staff members in the future. And this would really help us going forward. So I'd just like to thank you for your time, and I'm going to pass it on to Stephen.
Excellent. All right. Well, thanks very much, Aisha and Tom. We've just got a few minutes at the end for questions. I see there's a couple have been popped in the chat already, so I'll start with those. So in terms of training, query about whether we could run into difficulties down the line with the e-learning systems when applying a one-size-fits-all approach compared to whether we should have made reasonable adjustments. I assume that's meant reasonable adjustments to the training we're providing to staff. Welcome your thoughts, Tom, but my initial thoughts would be that yes, we do potentially have risks that the e-learning could be criticised as not being tailored to the role of the staff member. However, I would say it would seem that the ability to have a bit more information about the training that they've had would probably outweigh that. The fact that it may not be particularly or exactly tailored to their job, whereas we do see a lot of cases where we don't actually know the type of training that they've had. We know that they've had the health and safety training, but it was a few years ago and we don't have the slides anymore, whereas the e-learning systems will hopefully retain a bit more about what the sessions will have covered.
Yes, well, I think I agree fully with what you say there, Stephen, and I think perhaps one angle of this question is it okay to put everyone through a training via the internet route, potentially where people are not comfortable using the internet? And the answer to that is almost certainly no. It's not appropriate to just force the internet on people who don't want to use it. But when it comes to defending these types of cases, if most people in your staff, 90% of people are okay doing the e-learning and 10% require reasonable adjustments and you train them in a different way, then odds are that when an accident happens, it's going to be one of the 90% who did it this way rather than one of the 10% who couldn't. So I'm not saying don't have reasonable adjustments and push all of your training online such that other people aren't able to be included, but it's about being able to demonstrate that you've got a robust system of training. And as I think I said in my talk, one of the best ways to show a good system of training is not just to show a one-way flow of information from the top down, but also to demonstrate from the bottom up some kind of communication. So I'm not going to make anyone do it today, but whenever you go to one of these learning sessions, it's often a good practice to have a little quiz or something at the end of it, which tests the person's knowledge of how much they've retained at the end of the day. And so e-learning is just a really straightforward way of doing that because it's all handled electronically. If you don't do it via the internet, if you do it on paper, then a little 10-question quiz on bending your legs, not your back, or whatever it might be, it is an equivalent reasonable adjustment for those who are less able to use e-learning tools.
Yeah, definitely. Okay, good stuff. And then a second question that's been put up about Contrib, which I think is a very interesting issue generally on these cases, and noting that the Health and Safety at Work Act also places responsibilities for employees' safety on them as well as on the employer, and how much weight is given to that when arguing contributory negligence. For example, staff member using an emergency exit and suffering a fall where they shouldn't have been using that emergency exit, and there was no emergency or a drill. Now, I'd be interested to have Tom's thoughts on this as well, because I think contrib is something that we talk about a lot, but rarely see the successful arguments on, as much as if we're successful on the case, it tends to be other reasons rather than just on a large contrib discount. But Tom, what's your experience with contrib? I just get the impression it's a tricky one once someone's been injured.
Yes, it's relatively rare in the workplace type contexts, but it does happen, and it's exactly as the question says. And I think I said it when I was talking about health and safety policy. Health and safety policy in a work environment is the domain of everyone. It's not just a top-down thing from employer to employee. But when it comes to contributory negligence, the two questions a court is asking is, what is the causative potency of the thing that the claimant did wrong? As in, you know, what actually did their bit of inattention cause? If the thing was broken anyway, would the accident have occurred in just the same way, even if they weren't operating a mobile phone with their left hand while trying to do X, Y, or Z with their right hand? So you look at, just as a question of fact, what is the causative potency? But the other aspect of it is, what is the culpability? And that requires a little bit more of a kind of moral assessment of, are they blameworthy in a sense for the consequences of their actions in this case. And blameworthiness really, in my experience, depends on the communication of the risk, which we've talked about. And so really, in the example used in the question, someone using an emergency exit and suffering a fall when perhaps they shouldn't have been doing that, there was no emergency and there was no drill. Well, great. How blameworthy are they? Well, that kind of depends on what they were told. Can we as a defendant evidence that they were told, never use this exit unless it is an emergency? And if we can, great, that will up their culpability, their blameworthiness, and up the chances of contributory negligence. It might even extinguish the claim. If they weren't told that, it comes back to the slide where I put lemmings on it. You kind of need to express the obvious, communicate the obvious. Obviously, you shouldn't use an emergency exit when it's not an emergency. That's why it's a specially designed exit for that purpose. But tell people. If you tell people, it's so much easier to win than if you rely on the obvious. And the same is true of contributory negligence. The more you communicate to an employee about the risks that they face in the workplace, the more likely it is that a court will consider them to some extent blameworthy for their actions. Because, as the question says, it is absolutely true that health and safety in the workplace is the domain of everyone in the workplace.
Well, thank you very much, Tom and Aisha, and thanks for everyone for attending, and hope it's been a useful session.